5 seconds to go. Start. It is submitted that the appellants ought to have sought similar relief against the state governments. Stop. Thus, in his submission, a writ against the Union of India is untenable. Stop. Para. Learned ASG further submits that the writ of mandamus could only be issued against a statutory body when it is established that there is a duty cast upon a statutory authority and that the said authority has neglected to perform such duty. Stop. It is submitted that the appellants have not been in a position to point out that any such duty is cast upon the union to reimburse 100% GST, and as such, the present appeals would not be tenable. Stop. Para. Learned ASG, relying on various judgments of this court, submitted that in view of the overwhelming public interest, the union cannot be held to comply with the assurance given by it in the said OM of 2003. Stop. Para. In support of his submissions, learned ASG relies on the judgments of this court in the cases of Union of India and others versus VKC Footsteps India Private Limited, exemptions were to continue up to 2020. Stop. She was of the view that the centre must reimburse such units for the central taxes as jobs of more than 1 lakh workers were at stake. Stop. The Honourable Minister from Jammu and Kashmir had also supported the view of the Honourable Minister from Uttarakhand. Stop. However, the chairperson of the GST Council, that is, the Honourable Finance Minister of the Union of India, stated that the centre would only reimburse the units to the extent of 58%. Stop. He also expressed that the state would also need to correspondingly reimburse such units out of the share of revenue received through devolution. Stop. Accordingly, the following resolution was passed in the said meeting by the GST Council. Stop. Para. We, therefore, find that in the deliberations of the GST Council itself, it was observed that the states also need to correspondingly reimburse the industrial units which were entitled to exemption under any existing incentive scheme, out of the share of revenue received through devolution, which, as per the Finance Commission, stands at 42%. Stop. As a matter of fact, the state of Jammu and Kashmir has issued a notification dated 21st December 2017, thereby resolving to reimburse the remaining 42% of the CGST of the Union. Stop. This is limited until the period the Union scheme is valid. Stop. Para. It is further to be noted that the GST Council is a constitutional body. Stop. It has powers to make recommendations on wide-ranging issues concerning GST, including grant of exemptions from the GST. Stop. It also has power to make recommendations with regard to special provisions governing northeastern and Himalayan states. Stop. Taking into consideration that the units like the appellants have been established in the Himalayan and northeastern states based on the said OM of 2003 and that lakhs of persons are employed in such industries, we are of the view that it will be appropriate that such states should also consider to correspondingly reimburse such units out of the share of revenue received by them through devolution from the central government. Stop.